In a world where words and power and silence can be a sentence, comes a gripping tale of justice and forgotten defenses. Legal amnesia, the price of silence, delves into the heart of Rule 9 of the Rules of Court, where failure to plead can lead to a default judgment, stripping a defendant of their right to defend themselves. This film explores the consequences of neglecting to raise crucial defenses, leaving the accused in a state of legal amnesia, where their silence becomes their greatest enemy. As the clock ticks away, one missed deadline can turn into a lifetime of regret. Will the truth be remembered, or will it be lost forever in the silence of the courtroom? A story of law, loss, and the unspoken price of forgetting.
Oh, Marco, sabi mo magpapahinga ka na. Marco, ay hindi pa. Hello? O, ayan kasi. Marco, yung nanay mo, paying attention, Marco. Marco!
Hey, ma'am, where's your payment?
Do you accept Gcash?
We don't accept Gcash here. We only accept cash.
Heck, I forgot to withdraw money. I don't have money with me right now. Can you just accept my offer?
No, sorry, but I only accept cash.
Yes, I have cash. I can pay for your fare.
You don't have to, but since I am in a hurry, I'll take it instead. But please get it. I'll go.
Marco was confused. Upon reaching the house, he saw several people, strangers, going in and out of the house. Pieces of furniture are being taken out of the house and are being replaced by new ones. Then, Marco sees Phoebe, and he says,
"This is my house. Why are they taking my things out? Do you know who these people are?"
This house was foreclosed. I believe the previous owner lost the case. Wait, you said you were the previous owner, right? Where were you during the trial?
to which Marco says,
What? What trial? That's my car!
Rule 9, Section 3, Paragraph D of Rules of Court provides that a judgment rendered against a party in default shall not exceed the amount or be different in kind from that paid for, nor award unliquidated damages.
Hello?
Hello? Yes, just as I thought. You were in default. Summons was served to your residence, but you failed to answer. Section 3, Default Declaration of. If the defending party fails to answer within the time allowed therefore, the court shall, upon motion of the claiming party, with notice to the defending party and proof of such failure, declare the defending party in default. Thereupon, the court shall proceed to render judgment, granting the claimant such relief as his or her pleading may warrant, unless the court, within its discretion, requires the claimant to proceed or to provide with evidence.
Wait, how did you know that I was?
Do as I say. Set your watch to November 8, 2024.
Weird. Okay, if you say so. Wait, no, no. Wait! No, 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 wait!
The subscriber cannot be reached. Please try again later.
Shucks, where's the sticky note? What to do? That's why she wants me to set the clock back to November 8th.
Marco? Hello? Marco? Marco?
Bro, where are you? I'm trying to call you. You were declaring default.
Have you received any summons?
No, I haven't received the summons. However, I participated in the trial by filing an answer. Therefore, I waive that defense that summons was not served upon me.
Section 1 of Rule 9 of the Rules of Court states that defenses and objection not pleaded either in the motion to dismiss or in the answer are deemed waived. However, when it appears in the pleadings and the evidence on record that the court has no jurisdiction over the subject matter, that there is another action pending between the same parties for the same cause, and that the action is barred by a prior judgment or statute of limitations, the court shall dismiss the claim. Section 2 of the Rule 9 of the Rules of Court also states that compulsory counterclaim and cross-claim not set up shall be barred.
Oh no, 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 no. How can I undo this?
I have a lawyer here. She said you can still set aside the motion for default. Again, why did you fail to file an answer?
Okay, I'll admit it. I went to a basketball court instead of a trial court.
Section 3, Paragraph A, Rule 9 of the Rules of Court. A party declared in default may at any time after notice thereof and before judgment file a motion under oath to set aside the order of default upon proper showing that his or her failure to answer was due to fraud, accident, mistake, he or she has meritorious defense. In such case, the order of default may be set aside on such terms and conditions as the judge may impose in the interest of justice.
Genius! You should have gone to a lawyer. That's an inexcusable negligence. As far as I know, you can no longer set aside the order of default. Anyway, you shall be notified for further proceedings, but you can no longer take part in the trial.
Okay, I need to undo this. Section 3, Paragraph C of Rule 9 of the Rules of Court. Effect of partial default. When a pleading asserting a claim states a common cause of action against several defending parties, some of whom answer and the others fail to do so, the court shall try the case upon all the answers thus filed and render judgment upon all the evidences presented.
The court ordered that the petitioners failed to file the petition within the prescriptive period. Therefore, they can no longer enforce the foreclosure proceedings.
Rule 9, Section 3, Paragraph E of the Rules of Court, where no defaults allowed. If the defending party in an action for annulment or declaration of nullity of marriage or for legal separation fails to answer, the court shall order the Solicitor General or his or her deputized public prosecutor to investigate whether or not a collusion between the parties exists, and if there is no collusion, to intervene for the state in order to see to it that the evidence submitted is not fabricated.
Hey bro, what are you looking at?
Is my house still foreclosed?
What? Foreclosed? It's not your house. It's inside this house. Come on, let's go. Your fiancé is waiting.